So let's talk about real estate because that's a little bit easier to talk about, right? So you put your commercial real estate into the irrevocable trust. 2 years thereafter, it's bubble wrapped. It's protected from creditors. You have commercial property 1. You put it in the trust today. In 2026, that cure period has run, right? In 2026, you buy commercial property number 2, put it into the irrevocable trust. Till 2028, that asset is not yet protected. If you've got a business that is really just revenue stream without liability, which is not what yours is, by the way, if you have a business that is just, that you've got commercial rental property and you've got that in a business interest, that makes perfect sense to put into a revocable trust. If you've got a taxi cab business, you should not put that into an irrevocable trust because, and I'm going to talk to Josie as a lawyer for just 1 second. So the liability stays within all of the assets that are within the irrevocable trust. So then it will attach to the other assets. So you are not protecting sufficiently everything that's in the pot. Let me say this and I'll say it a million times. If you have a trust, the assets that are in the trust, assuming that you have a properly created and funded trust, assets in a trust do not go through probate. Hard stop, regardless of whether it's revocable or irrevocable. The difference, many differences, but one of the differences with irrevocable trust is it provides asset protection. That if you create a trust, it is a written document. The written document for many things is a roadmap about where assets go upon certain triggers. The person or entity who follows that roadmap is what's called a trustee. The trustee follows the roadmap, makes the distributions that have already been set forth. Do not do pay on death. For my realtor friends, do not do deed upon death because it creates challenges and a likelihood of probate. No matter how many times that the person at Bank of America tells you, no, we do not need to retitle this into a trust. Instead, just do a pay on death on the account. Hear my voice in your head where I say, no, do the work, bank teller at Bank of America or whatever bank it is. Here is my certificate of trust. I want an account in the name of my trust, not a pay on death. I can assure you with pay on death accounts, there will be a probate because the bank will not be satisfied when the person dies. You can show up with a death certificate. You could show up with the cold corpse of the dead person and the bank will say, I need a court order. What that means is probate. 100%, any bank will say, I need a court order. And that teller who told you that, oh, no, it's fine with a pay on death, you will not find her that day when the manager comes out and says, I need a court order. Insurance policies, VA benefits, IRAs, 401ks, none of those need to go in your trust. Those are all contractual relationships. Now, what I recommend typically is if you are married that you name your spouse as the primary beneficiary. And then if you've listened to me, you've created a trust and you name the trust as the contingent beneficiary. So that then those proceeds get held by the trust and then distributed by the trust. So an IRA, a 401k, other VA, other benefits don't have to go looking for the next heir at law, which will delay the process and delay your beneficiaries from getting the funds that they need. But you also raise another very, very important point, and that is that within a trust, you create a guardian for your minor children. Because otherwise, if you have if the children are left without a guardian, the court intervenes and will find the next person that the court deems to be appropriate. I love my mom with all of my heart, probably would not have wanted her to raise my children, right? I wanted to make those designations myself. I also, within a trust, can create other sort of expectations of what the guardian would look for your children, right? There are different types of guidelines that we build into our trusts. Some are very, very conservative. Some are very, very liberal. And some we call them sort of the middle ground of like parental guardians, right? So in other words, what would my mom, what would Aviva have wanted in those purposes? Let me talk about the car. Give me 1 second. Let me talk about the car one more time, right? So my son who wants the Ferrari, right? I think, you know what? At some point, my kid's going to need a car. And I'm going to put very conservative guidelines on that. The child can have a car when the child reaches a certain age, is insurable in his own name. It's not going to cost more than X number of dollars, and it's going to be a Volvo, right? Or it can be very liberal. Kid gets whatever he wants. Kid gets a Ferrari. Or it can be sort of the what would Aviva standard be, which would not be, what would the Jane, my standards don't matter. And that is the kid gets a reliable, ordinary car that is probably somewhere around a Camry, right? Somewhere that is safe but not necessarily a tank, and that is not a Ferrari ever. I'm not driving a Ferrari, the kid's not driving a Ferrari. That's just hard stop on that. To that point, a minor can own real estate in Nevada, which is baffling to me. But a minor cannot enter into contracts. So a minor cannot reach out to NV Energy and have electricity come to that property. The minor cannot have any other utility, although when my kids were minors, I'm certain one of them would have figured out how to get Wi-Fi. But could not sell, could not rent, could not do any of the things. So yes, a minor can own the property. It's a very, very bad idea. Part of comprehensive estate planning is not just planning for if you die, it's also planning for if you are incapacitated, if you can't speak for yourself for some period of time. The financial powers of attorney allow the person that you have nominated to get access to your bank accounts, to pay bills, if there's money that needs to be collected, to collect money. If you are in a coma because there has been a catastrophic car accident, it enables that person that you have designated to call Josie to file a lawsuit on your behalf. In the absence of that, you have to get a court order for that to happen. Takes time, money, effort, energy, things that you don't want to have to deal with when you've got a loved one who is not able to speak for themselves, or if you are the loved one who is not able to speak for yourself. The other thing is, for some of the life-ending periods of time, it's really, really hard. You see, my husband loves me, at least I think he does. My husband loves me, and I suspect that in the absence of appropriate documentation, my husband would do everything that it took forever and ever and ever to preserve my life. That is not my wish. My wish is, if I'm not coming back as me, I don't want to come back. Powers of attorney, financial powers of attorney, healthcare powers of attorney are vital for those purposes. Let me also say this, because I keep picking on my 18-year-old son because he is 18, which means, good God, he's an adult. If my son did not have powers of attorney, I couldn't get medical information about him because he is an adult and has not released that to me. Even if he were in a coma, even if he couldn't speak, I could not do that for him in the absence of powers of attorney. I would have to go get a court order.